Discharge by performance can refer to Section 38, subsection 1, where the parties to a contract must either perform their respective promise unless the performance is dispensed with or excused under this Act. If time is an essence, it can refer to Section 56, subsection 1, where the parties agree that the time is of the essence of the contract and the promiser fails to perform at or before the stipulated time, the contract becomes voidable at the option of the promise.
On 26 March 1961, the plaintiff had granted by the vendor an option to purchase the parcel of land that made up of Lot No. 145 and 165. On 12 October 1961, Lot 165 was acquired. The option received by the plaintiff on 22 September 1961 and requested the vendor to deliver document of title in exchange for the check $33,500 as deposit. Next, the vendor called at the office of the plaintiff's solicitor, but no document of title is produced. On 12 October 1961, the plaintiff took back their check but paid similar sum to their solicitor to pay out to vendor when the ownership details were satisfactorily settled. On the same day, vendor purchased the lot 165 from the beneficial owner and requested the plaintiff to pay 90% of the purchase price in advance. Next, on 21 October 1961, the vendor applied to the collector for variation of the express, but on the 7 April 1962, the collector refused the vendor's solicitor, wrote to the plaintiff's solicitor, conveying the information and concluded by requesting an advance payment. Last but not least, on May 1962, the vendor's solicitor wrote to the plaintiff's solicitor that the vendor considered the agreement at the end. The plaintiff claims specific performance of the contract.
Judgment. On the day of the High Court held that certain clauses in an option agreement to purchase a parcel of land were reciprocal promises intended to be simultaneously performed within the meaning of Section 52, and in the absence of express term to contrary, it was a well-established practice that in the contract for the sale and purchase of land, payment not a condition precedent to execution are transferred. The plaintiffs were allowed specific performance of the contract, and the defendant contention that the plaintiff had default in payment was rejected. Other than that, the plaintiffs were entitled to specific performance as the sum of money, $33,500, was ready and available by plaintiff at all times to make payment to the defendant upon their production of the relevant document of title which they failed to do. There was no evidence of any facts which could reasonably have led the defendants to conclude that the plaintiff were unwilling to complete the contract. There is no evidence that the plaintiff ever received a contractual objection by the defendant on May 8, 1962.
Fraud is generally defined in the law as the intentional misrepresentations of material existing fact made by one person to another with knowledge of its falsity and for the purpose of inducing the other persons to act, and upon which the other person relies with resulting injury or damage. Fraud may also be made by an omission of purposeful failure to state material fact, which non-disclosure make other statements misleading. Misrepresentations refers to a statement made by a party to a contract that induces another to enter into a contract which can be interpreted as false or untrue. The misrepresentation must be both false and fraudulent in order to make a party making it liable for damages.
However, under the Contract Act Section 19, misled party has duty to exercise due diligence. For the case Tan Chai Chu vs. Eastern Mining Metals 1965, contract not voidable despite the misrepresentation as the party has means of discovering the truth with ordinary diligence.
The judgment is made by YVCJ Borneo. Firstly, there was insufficient evidence to support the finding of fraud. This is because in this case a high standard of proof is required where fraud alleged. There was no enough evidence to support the finding of fraud against either appellant, and there can be no rescission on the grounds of fraud. and the award of damages for fraud should be set aside. The trial judge found both appellants had acted fraudulently. This is because the second appellant had knowingly and fraudulently shown the geologists the wrong pieces of land, while the first appellant was liable for second appellant because it is his asset. Lastly, the contract entered into between the respondent company and the appellants were not viable because of misrepresentation. It was undoubtedly misrepresentation because the second appellant represented to respondent that the area inspected was included in approved application. The company made no further effort to visit the area and decided to conclude the agreement without further.